right, I decided to keep all of our CA team on here. Today, our presenters will be Barry and Hannah. First, we have Barry Ansbacher, who is the founder of the firm. He brings over 30 years of legal experience. Barry is the only attorney in Florida who is triple board certified in real estate construction and condominium and planning development law. He is recognized in community association law and has been instrumental across the state. Joining him today in person will be Hannah Rullo. She is our partner and she focuses on CA here. And Hannah is known just throughout many trusted advisors, as being a trusted advisor to many associations. And we also have a wonderful Emily Dominguez and Alejandra Gonzalez. These girls are also a part of our CA team. Everyone is very hands-on and they just come back with a really strong background in CA. And I just overall working with them is wonderful. They're very passionate about their community that they represent and take care of. And that's what we're here for, to have these for you complimentary, but also to help guide you. And without further ado, I will be passing it off to Barry. Oh, and just so you know, we are a statewide firm. So we are all along the state of Florida, Jacksonville, Coral Gables, Jacksonville Beach, St. Augustine, Orlando area, Tampa, and Fort Lauderdale.
Well, good morning, everybody. I want to thank our co-host, Vesta Property Services. Rhiannon, you want to stand up? Sure. We have Rhiannon Casino, who's one of the general managers for Vesta Property Services. We want to thank them for the longstanding relationship we've had with this community association management and recreational amenity management. They do both services, as well as I believe CBD as well. So they do it all in Florida. So we want to thank them for joining us for this event today. And we're going to try and induce Rhiannon maybe to join us for some of the Q&A for those questions that you have. Maybe we can talk her into that for this afternoon. I am going to ask Kelly if you can turn the chime off, please, as much as we're enjoying that. If you could please disable that. What's that? Paula, please disable the chime on the alarm. Oh, thank you. Okay, without further ado, so I'm going to go into the legislative process and a little bit of the recap of some of the past laws, and I want to come in here with it. Why do I really beat on the legislative process? How many people in the last week have seen a negative story about homeowner associations, right? Okay, now I share a YouTube stream with my 13-year-old daughter, so I get all of her stuff. So I got a lot more K-pop or K-pop than I ever thought I would see. But even on the stream where it's her algorithm of a 13-year-old, a day doesn't go by that there isn't some negative portrayal of homeowner or condo associations. And so that has become the narrative, right? Mean, horrible people wake up every morning to punish poor homeowners, right? That is why we're all involved in this. And the problem is, if a narrative goes unrebutted, doesn't that become the reality that the legislators, that the state senators and the state representatives here in Tallahassee? That's why as we go through the legal update, you hear, why are they just beating on us? We're unpaid. We're just trying to protect our home values in our community. You're making it harder for us to be a director of a HOA than to be a state senator. And the reason why is because those are the messages that they hear. And right now, they're gearing up. I looked today, there are 518 bills that are already pre-filed for the January 2026 session. Right now, your state senator, your state representative is in the district. They're not up in Tallahassee. Come January, for January and February and the first part of March, that 60-day session, they're going to be in Tallahassee. They're going to be hard to get to here. Right now, bring them here. What's a great way? What do politicians love? The opportunity to meet with voters, right? They're elected officials. What do y'all have? You have board meetings and membership meetings, the opportunity to meet with people and their constituents. Invite them to come to your board meeting, invite them to come and speak to your annual meeting, establish a relationship, let them understand that you're a resource to explain, hey, you may not realize the unintended consequence. You aren't aware of how this is hurting us, how hard it is for us. And we're not bad people, we're just citizens serving our constituents, just like they serve their constituents, right? You're elected officials, just like they are. So I'm encouraging all of you, between now and January, when the session starts, reach out to them. And let's go a little bit with it. Session starts January 13th. They've already had 2 weeks of committee meetings. So the process begins, and by the time we start January 13th, your ability to get involved is gonna be hard. You can still get involved though. And how do you get involved? Right here. When I was a young man and I was working as a lobbyist for the city of Gainesville, knowing which bills were filed and which committees were hearing, that was like secret sauce, right? You had to be up there. Right now, it's on the website. Now, by the last couple of weeks of session, it falls a little bit behind. But you can go on here and search. Right now, there's only one bill filed for 718 or 720 directly, but you can look on here and you can see which committees are hearing it. And you can see which legislators are on those committees, because that's where you want to reach out. By the time it gets to the floor of the House or the Senate, it's really too late to change things. But if you look at these bills and say, hey, somebody on that committee is from my district. How many of y'all know who your state rep is? Raise your hand. Some of you. How many people know their state senator? All right, those are the people you want to reach out to, see what committees are on. Bills get introduced and then they get referred to committees, typically 3. So in order for a bill to become a law, it goes through all those committees, and at each committee stop, it can be killed or it can be amended. Then it goes to the next stop and the next stop. And if it passes all the referral committees, then it goes to the floor of the House or the Senate, then it goes to the other side. Often there are companion bills, so they're running on both House and Senate concurrently. So you want to reach out to the people on both with it. So I want to talk about, just give you an idea of what's coming up in terms of legislation. I looked just a few minutes ago, and what we have coming up is House Bill 65 and Senate Bill 360. Home inspectors. How many of us have ever dealt with a home inspector? All of us deal with, right? So what they're trying to do there is increase regulation of home inspectors, not a lot, but a little bit. But they're trying to add a requirement that home inspectors have to carry malpractice or errors and emissions insurance. A lot of us have heard about it, especially if you deal with, hey, they missed this, they didn't do that. So maybe that's something you support. Maybe you oppose it, but it's something to know. Senate Bill 78, House Bill 185, sales tax exemption for hurricane windows, doors, shutters, garage doors. House Bill 79 is an interesting one. Landlords will now be criminally liable if they rent a home, condominium as well, and the pool safety is not meeting code. Or there is a stormwater pond within 150 yards of the home, and somebody might be hurt. So let's think about that. I've seen some grandfathered condos or HOAs, maybe your pool doesn't meet those standards, which is even higher standard on commercial, but it's something to keep in mind. Property insurance, how many people have seen their property insurance go down in the last year? I see one hand in the back. How many people have gone up? Okay, and that was after we were all promised if you just eliminated all the rights of the insured, rates will go down. I often laugh about it because they're saying your rates will go down, but you may not have any meaningful coverage. So it's kind of like if I don't drive my car, I get great mileage, right? It just doesn't get me anywhere. In any case, there is some talk about moving in Senate Bill 108 and House Bill 41 about maybe adding back some rights for the insurance. In other words, if your insurance company just doesn't pay a claim, that maybe they would be liable for your fees and costs if you prove they wrongfully withheld the claim. And then one that I think is really important is House Bill 255. House Bill 255 is one that says that the time limit to bring a construction defect claim will not be told. So that everybody understands, when I started practice, you had 4-year limitation period from when the project was complete or you took occupancy, but in any event, 15 years. and then it became 10, and now it's 7. And not only is it 7, it's now 4 years building by CO. So in a homeowners association, by the time you have turnover, your clubhouse amenities or buildings may be out of time. Condominium had tolling and then they eliminated it, but then they brought it back in a year ago. So now the time period for a condominium association claim begins at turnover. And this is a attempt to get rid of that tolling. So that now, by the time a condominium turns over, which has to be 7 years after the declaration, all the rights of the unit owners may expire. I don't think it's a particularly good bill, but it gives you an idea of why you want to stay vigilant on those issues. And I assure you, there will be more. A year does not go by that there aren't at least a dozen bills on homeowner and condo associations. And we'll be back here next year and bringing you up to date. So I'm gonna go real quickly through the 2024, in case you missed it. We'll take a break and then Hannah's gonna give you the 25. So we're going back a little bit, but I think these are important. The 24 had some really new directions. Because how many people here have professional management for their association? Most all of us? Okay. We are big believers that it's a three-party relationship. A good involved board of directors, professional community association management, and legal counsel, we feel like really gives your community the best chance of getting it right, and everybody has their role to play. One of the things that has been getting a lot of attention is laws dictating what community association managers can do, what they can't do, and what they must do. And the reason this is important is directors rightfully treat the manager as their agent, but the manager has licensure duties and they're becoming more and more specific. So you might hear from your professional community association manager, I appreciate that's what the board wants me to do. My professional obligations don't allow me to do that. And frankly, these are probably good things that the board should take pause on doing. So some of it is also like lawyers, doctors, everybody has bad apples in their profession. And so some of these are worst case scenarios are also regulated. So one of the issues that came up is a duty to turn over the records within 20 days of written request or termination. Now, this is really interesting because I've had some management companies that are telling me, hey, I've been told to turn over all the records and maybe they aren't all digitized. But if I give them all the records, how am I going to perform my duties? So kind of keep in mind with it, it might make it a little bit hard with it, but they've got that in there. They've added subsequent as well, that there are actually penalties up to $10,000 for a management company that doesn't comply with that. And so there were amendments to this. So what you're going to see is the pattern in 24, they had restrictions. And in 25, they said, well, maybe we went too far and pulled it back a little bit. So conflicts of interest is a bigger and bigger issue. I'm going to give you Ansbacher's golden rule. Just don't do them for directors. It always starts out with my company, my cousin, my brother will do it for less money. Whatever savings your community might get is not worth the grief, right? It is absolutely not worth it. But for managers, what they're talking about now is conflicts of interest for the management company, anybody employed by the management company, not just your manager, and their relatives. And so this is really broad and it's a conflict of interest, but I want to go back for a second. There's management conflicts where you have some companies that have affiliated entities, whether they do landscaping, whether they do insurance, anything else. So in 2024, they really didn't have a recognition of that. In 25, they came back and said, well, if these relationships are disclosed in part of the management contract, then it's part of the original relationship that you made when you hired that management company. But let's talk about how broad it is. We're fortunate enough to have Rhiannon here. Rhiannon, do you have any siblings?
I do.
Okay, how many siblings?
What?
She has one sibling, sister or brother?
Brother.
She has a brother, all right? So what's a conflict of interest? If Rhiannon's brother Some 3 degrees of consanguinity. So here's Rhiannon, that's her brother, that's 2 degrees. 1 degree, excuse me, 1 degree. Her brother has a financial interest in a business that's going to do business with your association. Let's say the landscaper, we'd say, okay, but what if her brother has a 401k or a mutual fund? And in that portfolio is a public landscape company. It's pretty broad. In other words, some of it is, but what if her nieces and nephews and their 401k? So you do the best that you can, but those conflicts you can see. And by the way, for directors, it's also 3 degrees. So you can see it's broad. So let's talk about what came out. Management company conflicts or presumed conflicts. We're calling them conflicts of interest. It doesn't necessarily mean a bad thing if the affiliated service that the management company is providing is something that is giving you better bang for your buck or better control. In other words, that's a business decision the board makes. And those relationships should be disclosed and understood as part of the management contract. So if it's in the management contract, then you're covered. Otherwise, any contract you sign needs to be disclosed that there is a relationship on the face of the contract between the management company or the manager or somebody else with the management firm and that company, so it's all above board. It should be, takes 2/3 of a vote of the directors, but here's the other. If the amount of the service exceeds 2,500, the bill as originally introduced in 2024 said you must go out and get multiple bids. In 2025, they came back and said, no, not if it's one of those affiliated relationships that you put in the original management contract, which makes sense because that was part of your engagement in the management contract. You knew you would have this affiliated entity that would be working with you. They then had that it would be disclosed at the next member meeting in a year from now, which really was kind of silly. That, 9 months later, we're going to talk about it if there's a problem. If it's not disclosed, the board can terminate that if it's not disclosed to it, and there can be DBPR discipline. Now, let's move over to here and talk about education. We're all here today. So education waivers are gone. It used to be you can sign an affidavit that says, I know the rules, I'm good, thank you very much. Now, you may still have to sign the affidavit in conduct, but you have to go to the education course, and that is what we call the 4-hour certification. And why do we call it the 4-hour certification? Because it has to be 4 hours. Now, homeowner associations arguably have to have the same materials, but not 4 hours. We don't know a way that you can teach the required topics in less than 4 hours. So I know at our firm, we give one 4-hour course for both. So let's talk about the timing. Anytime you have a new director elected or appointed, within 90 days, they need to be certified. Now, what happens if you go on and off? You go off and come back on, or at another association, you have to get certified again. There's a special exemption for developer appointed directors that are really serving as an agent of the developer. Now, this is where it gets confusing. And sometimes people say, why is 718, 720 different? Because it's made by a committee. If you've ever cooked by a committee, sometimes it doesn't come out so well, sometimes it does. So it gets a little bit different. So let's talk about it. Condominiums, once you get certified, you have to get renewed every 7 years. And what is the term limit for condos? It's 8 years. Now, you can continue to serve past 8 years if nobody else steps up. Homeowners, every 4 years, you have to be recertified. Now, this is completely new. And in fact, it may be the only place I can think of where you are required to have annual continuing ed for an unpaid profession. In other words, everybody understands if you're a cosmetologist, you're an attorney, you're a community association manager, that's your profession. You have to have annual continuing ed, teacher, anything. But as unpaid volunteers, you're still required to have continuing education. And what are the requirements? Condominiums, 1 hour per year specifically in legal update. Ta-da, you're here. Okay. That is what managers have had to have for a long time amongst their component of credits. So this is the legal update credit. Homeowner associations have to have 4 hours per year on a variety of topics, and this course should count for that. And for those who have taken our board certification, our board cert is also a continuing ed class. But what's the 8 hours? If your homeowners association has 2,500 or more homes, you've got to do 8 hours a year. Now, 8 hours a year, I believe, is more than a lawyer needs to have. I think I'm saying it's a lot of credit and hours to do it. So it's a pretty significant requirement, and it's a lot. By the way, how many people know what is the continuing education credit to be the governor, a state senator, a state representative who probably has a lot more authority? 0, right? It's interesting that they're very good about imposing on us, not necessarily amongst themselves. All right. Hurricane protection. Attempt in 24 and 25 to make it easier for condominiums to do modifications to harden the buildings. And the problem that you have on any of this stuff is the statutes are contradictory. In some cases, they say the board can just do it. In some cases, you still need a member approval, and whether the governing documents still constitutionally override this. So here's the issue. There's also something you need to keep about. If you decide to go and make changes, and you change it for everybody, you may owe a check to all the homeowners who already did it themselves that you weren't counting on. So before you undertake a capital improvement project, this is one of those times, a lot of times I say, maybe you don't need a lawyer. You need to sit down with your lawyer and see exactly what is the vote required and how it's going to be. Because if you make changes in a condo and they're not approved under the law, arguably you'd have to rip them out and then go get the correct vote and do it again. All right, you talked about the requirements of managers. One of them was managers must attend 4 meetings a year, quarterly. Now, why would an association not meet at least quarterly? Sometimes you have condominiums where there's 3 units or 2 units, it just doesn't make sense. But regardless, if you've got more than 10 units, they have to meet quarterly. This is really interesting. You have to allow in condos questions. That hasn't gone to HOAs yet, but whatever goes in one universe usually makes it to the other, right? It goes back and forth. So is allowing members to ask questions a good idea? Maybe, right? Are you still cheating the association? Are you still a horrible, miserable thief? Are y'all, in other words, sometimes those questions are somewhat charged, not helpful. They're not saying what day is garbage pickup, right? So the question is, if anybody's dealt with conflict resolution, our advice, and Rhiannon and I have had this conversation, is to de-escalate, right? Thank you very much for your comments. So the question is, do you have to answer? Now, the rule says no. So you have to allow the questions 4 times a year. You don't necessarily have to comments on. Assessments now require 14 days advance notice before you're going to do assessment or special assessment. And meeting notices for condos have to have the contracts that are being considered. Also part of the notice. So for those of you who don't have a half-mile long bulletin board, I'd suggest print very, very small. Records inspections. I think records inspections are the button presses of the world, right? People who want to annoy managers, annoy the board, records request, records request, records request. The intent, I think, makes sense. It's transparent. They should be available. But it tends to be one of those circumstances where some bad actors will abuse it, right? So what's the remedy? The remedy has been get it on the internet. It's available and takes that pressure off. Also, if you have changing directors, changing management, things like that, maybe there's some continuity to that data. So the first one, condos over 150 had to have their records online. Then they added, beginning January 1 of this year, homeowners associations with 100 units. But this is the change in January, 25 unit condos have to have their records online by January of 26. Now, this is really important. It's not all your records, but it's most. And I would suggest to you, you might as well go that last mile, right? If you're going to all that expense, and that way everything is online and it makes the process easier. But here's the issue. You have to redact confidential information. So it's not just a matter of digitally tossing it out there. Well, if confidential information were social security numbers, driver's license numbers, you probably haven't captured much of that to begin with. But in one of the stupidest things in the world, email addresses are considered confidential information. And everybody who emails you has the email address on there. What's the solution? Maybe there's some algorithms that look for that @ symbol and can do a redaction through some of the AI tools. Can you get a waiver of that redaction whereby you say anybody who emails us, that's what happens to public records, you recognize that you're waiving that? I don't know a perfect answer. I think it's kind of silly on there, but that is one of the requirements. And there may be a liability if you don't redact that. I'm not sure what the liability would be. Somebody got a junk email, I don't know, but in any case, that's really what runs the expense up from that. And there is liability in the statute for knowing an intentional disregard. I can understand you throw somebody's credit card number up there. I kind of think, how would an email result in liability? I don't know, or address. Important. How many of y'all have a written records rule that has been adopted on records retention? All right, and now a lot of people have it in their declaration articles or bylaws, you have to have a rule. If you haven't adopted a rule, I'll give it to you for free. I move that we adopt the following rule. Our records retention shall comply with the requirements of chapter 720 in our governing documents. All in favor, type it up, you got a rule. That's all it requires, but you do have to have one. 7 years is the default retention. Criminal penalties. Condo and HOA, you destroy records, allow them to be destroyed. As a director, you may have a criminal penalty, and if you are alleged to have committed a crime, you may not be protected by your D&O insurance. Last thing about records. Condos have to do this, but I'd suggest HOA directors under your fiduciary duty have the same requirement, that if there are missing records, you're missing minutes, you're missing contracts, you have a duty to try and get them and restore them. I'd suggest even HOA directors have that duty. Call the past president and see what you can do to pull them back. Condos have to organize the records to facilitate inspection. How many people remember E.L. Koningsberg, local artist, author? No, Mixed Up Files of Miss Basil Frankweiler. Anybody? No hands. Okay, that used to be a Newbery award winning. And that premise of the book was the files were so mixed up, nobody could find anything. So it's a good children's story. So you can't have them as a hot mess, which I don't know that anybody would. And this is the last thing. Condos have to have a checklist that documents what somebody asked for and what they were given. It may not be a bad practice for HOAs too, as people get more litigious, because what happens is you make the records open, I didn't get them, they file a DVPR complaint against the manager's license, they file a division complaint against the association. Having some type of documentation of the process is probably a good idea for that.
Sir,
Yeah,
going back to the destroying, obtain, obstructing the information.
right.
How far back can you ask the past committee for that?
So
Is there a statute of limitation?
the question is, how long do you have to retain the records? The answer is, the statute has a default of 7 years for most things, but there are certain things that you should keep perpetually, like your minutes, your governing documents and such like that. But the statutes themselves, if you look in 718 and 720, specifically provide the time for each type of record. Yes, sir, in the back?
Yes, approve the minutes. And all of those records from the cast have to be available online for a condo.
I have to look at 718 to see because there's a list of everything that's in official records and then a sub list of what has to be online or not. I don't know offhand whether perpetual minutes are or not required to be online, but I'll go back to my premise of my advice is universally, if you're gonna go to the expense of having all the online stuff, get everything you can on the incremental cost is so little. And what you're trying to do is avoid that friction point where somebody says, I need to do an official records request, where you can just keep directing them to the website.
Our association was built in 83.
Right.
That's an awful lot to have to try to digitize and put online.
Well, the question was, it was built in 1983, but most of that stuff has aged out, but the minutes themselves are generally a page, 2 pages, are probably not that burdensome to put online. But getting your stuff online really does involve 3 things. One, sitting down and having an understanding of what needs to be retained and what needs to be put online. 2, looking and talking to vendors about the process of getting it digitized, doing the redaction. It's a big project and it can be expensive. And this is the other thing, going forward, data, you remember the floppy drive, right? What was it, 360K? Now we talk in terms of terabytes and gigabytes. So to some extent, data seems free, but nothing is infinitely free. So one of the things I recommend is reduce. So let's say somebody comes in and they're very proud of their home restoration and they have 30 detailed sheets of their plans they want to submit to ARB. I'd suggest you say, you know what, keep 29 of them. We just want the exterior site plan. We don't even want it. Don't receive it. Keep it. It doesn't need to be digitized. It doesn't need to get in your file. So to some extent, you can limit some of this at the intake stage with it. HOA enforcement. I started off our conversation this morning about the perception of HOA lawyers, HOA directors, HOA managers, right? The reaction has been repeatedly, and in fact, there was one legislator who said we're going to repeal HOA completely. I mean, it's these worst case scenarios of people either acting inappropriately as directors and maybe overreaching, or people misstating it to the record, because it's not a news story. HOA collects its assessments to maintain property values, right? That's not the evening news. So what are the laws that they came up with? Enforcement by an HOA must be reasonable and equitable. I would suggest to you that has always been the case. Well, how do you keep it reasonable and equitable? Our advice has always been that you depersonalize it. That you go through and you sit down with your manager and you say, what are the common violations? What are the issues? Maybe it's mailboxes, sheds, noise, and you take the top 10. And you say, okay, what constitutes a violation? So let's say yards. And you say, okay, for yards, what's the standard? In other words, help your manager help you by having a standard. When you're driving around, what's significant enough you want us to flag it? Maybe if you see something that's 2 feet by 2 feet or larger as observed from your car. Is it going to be one dandelion? In other words, talk about what the standard's going to be. And then what should the reaction be? Courtesy warning, a fine, in other words, and that way you go through and define the frequent events. If you see this and it crosses this standard, then do that, right? Now your manager has the guidance to provide you better service because you're giving them better policy. And then you have as part of your enforcement policy, if one, you see something and you're not sure it trips the threshold, or 2, if there's some other apparent violation that's not enumerated on this list, come back to the board for clarifications. Everybody say? So you have the autopilot that doesn't depend if it's Sally or Mary or John. There's no personality issue here. It's when you see this, past this threshold, do that. And you publish the schedule, and everybody knows, because why? One of the things that we all feel better about is I'm being treated fairly. We get that back from kindergarten, right? No front seats, right? I mean, we all know that our feeling of fairness is not so much what the rules are, but how they're being applied, transparently and evenly. Yes, sir.
When was this written up? When was this?
This became law in 2024.
2024.
Correct.
So it wasn't enforced when the Miami building went down.
Well, some of these things, in terms of the enforcement and things like that, I would argue have always been a basic fiduciary duty about. As a director, you have a duty to act in the best interest of the association, which I would suggest is treating people fairly and equitably. Let me give you the opposite. I'm parking in Walmart and somebody cuts me off, and lo and behold, it's one of my neighbors, and they're coming to me for an ARB approval the next day. Or maybe their home is not there. That's the type of thing they don't want you to interject, right? They don't want it to be based upon which politician's on their bumper sticker. They don't want it to be on extrinsic information. That's why I say, have a policy, because what is one of the best things a professional community association manager gives you? Detachment. Why they care about the job they do, they care as a professional. They're not a member of your community. They're not getting entangled in these personal issues, and you have that separation, that neutrality, right? Good manager is going to take direction from the board, but they're going to be personally neutral. They're not dealing with the community that a resident would have with another resident. And that detachment gives you a level of professionalism in the enforcement, but give them the tools of, these are the standards. We don't know who's violating them. It could be the directors. I know with Rhiannon, it's been more than one occasion on a board that Rhiannon serves where the directors said, yeah, I got fined for that, or I got a notice for that. Why? Because the directors had a policy. And when her people went around driving the neighborhood, they weren't looking and saying, is this John Holmes or Mary's home? They were saying, here's the standard, and I'm gonna follow the process. When somebody applies for ARB, they need you to specifically say, why are you turning it down? Right? Makes fair, it's due process. You're turning it down because your shed is too tall and it violates this standard. Another one is the drone issue. They have an issue with Google Earth and drone that you're violating people for things that can't be seen from the front yard. However, they don't say that it has to be viewed from the front yard. So this is where words matter. If the violation is theoretically visible from the front, from the street, you can still enforce. And they don't tell you what that means. For example, so my wife, who is 4'11.5", is standing in front of the fence. Is it a different standard than somebody who's the new Gator player? What is he, 7'9" or something? So it doesn't have to be viewed from the front visible. This one here is one where legislators don't know what we're doing. They now require the hearing before you fine, right? And this is the problem. If the fine event, the violation is cured up to the moment of the hearing, you can't take any action. Well, think about the burdens that are. And that means you have to have your management go out and do another last minute inspection. And people can keep violating, take it right up to the hearing, cure, violate, take it up to the cure. And you wouldn't have that in any other instance. In other words, imagine every time you got a speeding ticket, yep, I've stopped speeding, do over, I'm not speeding anymore. No attorney's fees and costs available to enforce your covenants with the fine. Now, this brings up a question. That's all if you're doing a fine process. The requirements and restrictions they've done on fining, I would suggest to many communities, you may want to say it's just not worth the effort. We're no longer going to fine. We're going to just go to court and seek injunctive enforcement of the covenants. It's something to think about whether that's, as they say, whether the juice is worth the squeeze. Now, one of the other things they've done is they've outright said, we're gonna micromanage. They don't have enough to do in Tallahassee. We're gonna micromanage HOAs. Yes, ma'am, in the back.
I can go back to the, not visible from the front.
Right.
Base of commercial. What about when you have a one-story house and a two-story house beside of them, and you're sitting upstairs and you can look into their yard.
Right, so-
and full of junk and.
Right. The question is, what if it's visible from the neighboring house? That is one of the things, if it can be viewed from the neighbors. Likewise, in my mind, it doesn't say I can't stand on a ladder to view it or stand on my neighbor's roof. So I believe the text as written, unless there's some judicial clarification, essentially is meaningless. That anything is theoretically visible from off the property. So that would be an instance. So let's go back to the things that they don't want to allow. They're saying you can't prohibit commercial vehicles at all in a gated neighborhood. Commercial vehicle is something bigger than a school bus. Right? I mean, that is something many of our gated communities are saying that was an unconstitutional change and they're not following it. You can't require homeowners to use licensed or insured or preferred contractors. The board can still require it for themselves, but if a homeowner wants to have an illegal contractor come in, now you'd say to yourself, why would I care? Well, what if you have townhome? And that illegal work done on that roof might cause leaking elsewhere or such like that. So I can understand maybe in a single family detached residence, but if you're dealing with townhomes or such, I think it's problematic. Yes.
I just have a question regarding, let's say the owner puts in an ARC request for their roof. Isn't usually part of the ARC process to require license and insurance from the vendor that will they be conducting the work?
The question is, many ARCs make verifying that the contractor's licensed and insured part of their vetting. In the arena of an HOA now, if you believe that this law is constitutionally applicable in your community, you know, it would be illegal to do that as a consideration. Again, let's go to the next thing. Garbage cans. There's a 48-hour amnesty for garbage cans. Again, this is where I'm saying, why in Tallahassee are they micromanaging this stuff? Because I'm sure some constituent came out and said, you know, I had a situation where my can was out 30 minutes too much and I got a fine. So 24 hours before pickup and 24 hours after pickup, you are not able to enforce a violation. And my very favorite are holiday decorations. And end on that. So first of all, it doesn't say legal holidays, it says holidays. So how many people see the Hallmark? Today's grandparents' day, today is siblings' day, today's stepsisters' day. I don't know if somebody has a phone, somebody hit Siri on their phone and ask what holiday today is or special day is. What are you in?
What holiday is it today? Sorry to disappoint you. Today isn't a holiday here.
Today maybe.
Monday.
Right.
Monday.
And here's the issue, you cannot enforce restrictions on a holiday until you give them the week warning and they take it down and then they get out of jail free if you believe this is constitutionally applied. Well, what could go wrong? I can imagine somebody celebrating Robert E. Lee with Confederate flags would not be well received necessarily by their neighbor, followed by Lincoln's birthday. So I'm saying, when you look at these legal holidays, it really basically says you can't regulate anything in people's yards. Which, you know what? I'm a libertarian. If you choose not to live in a homeowners association and it's not a danger, maybe that's correct. But if people have made the choice that said, we want architectural controls, we want a certain standard, we want the property values, and they've all chosen that, why is the legislature saying, no, we want this? Now, probably what they intended was around Christmas to allow traditional Christmas ornaments, but that's not the law. The law would allow you to stick these neon pink flamingos up for each holiday. You get your warning, take it down, they take it down within a week, and then they stick it right back up because by golly, there's another holiday. So this is the outcome of what I call unintended consequence. So with that, I'm going to let Paula come back up here so we can go ahead and recess us for some lunch. I want to thank everybody. First of all, it is our joy to welcome all of you here in person. For those of you on Zoom, we are going to be doing more and more of these live events. We truly appreciate the opportunity to be face to face and get together. I'm going to turn it back over to Paul. Thank you so much for joining us here today.
So we will break so you guys can go and enjoy our lunch that we have here for you.
Let's all go to the lobby. Let's all go to the lobby. Let's all go to the lobby to get ourselves a treat.
All right, everybody,
We hear that.
we're gonna get started again here in just a moment. And we're going to get into the 2025 new laws. For those of you that I don't know, my name's Hannah Rullo. I am an attorney here at Ansbacher Law. It's so great to see everybody, all the familiar faces. Thank you guys so much for coming today. We're so pleased to be hosting this with Vesta, and I love seeing so many of our Vesta communities here as well. We've got one of our favorite managers and the general manager for Vesta. I know Barry introduced her earlier, Rhiannon, who will be joining us for the Q&A. She stepped out for a moment, but let her know she's not done yet, guys. All right, so let's jump right in. For everybody, one of the best pieces of news that our clients received is that FinCEN is dead. Who killed it? The courts. Yay, thank you, judges, right? It went through several different federal courts of appeal before finally it was killed altogether. And so those of you who may remember, at one point last year, within the last year, directors for not-for-profit associations like yours were required to provide the government with very personal identification information related to and specifically involving financial assets. It was a deterrent for a lot of our directors, as you can imagine, because of that requirement. And so after several different suits were filed in several different states, because it was a federal requirement, the courts did kill it. So if you had previously submitted that, sorry, you were compliant, and then they said you don't have to do it. So unfortunately, you know, we did have some associations that did that. There were others that held out. This time around, you guys ended up being right, but for all you know, they could have, you know, not killed FinCEN, and then you would have not been in compliance. So we do recommend always kind of talking with your counsel before you do something like that. I know we've got a hand in the back, but we've actually got people online too. So at the end, we'll go through questions that way they can kind of participate as well. All right, so the big bill this year, and really the only major bill, is 913. This is applicable to condominiums only, right? As it relates to community associations. There are some management specific changes from 913 as well, but HOAs, keep in mind these new updates. Oftentimes, and I know a lot of you are familiar with this, the condo statutes are actually an indicator of what is soon to come for HOAs. And so it's very likely that a lot of these new provisions will eventually apply to your homeowners association in the next few years, if not within the next legislative session. So what did 913 do? One of the biggest things it did was it explicitly allows condominium associations to conduct meetings by video conference. The legislator also defined what video conference is because we needed it, right? The lawyers will argue about it. And it means real-time audio and visual meeting between two or more people where you can both see and hear. They just wanted to make sure you knew what audio and visual meant. So that is occurring. That is a video conference for purposes of the Condominium Act. If you choose as a condominium association to conduct a meeting via video conference, and please be aware, it is not required, right? We've got an association right now that says we are not doing video conferences. They may not have that option in the future, but right now it is optional. So if you elect to have your meetings by video conference, you've got to do a few things. First, your notices for those meetings must include both a hyperlink and a call-in telephone number so that members can participate through that video conference or by calling in, right? If you use Zoom as a platform like our firm does, then you're probably familiar with the invitation. It typically promulgates a dial-in number along with the video conference number. That way your members will have both of those options satisfied. Now, this has been a question that's kind of been alluded to up in the air, but now is explicitly stated in the statute. You must have a physical location for your members to participate in your meeting. So you may do your video conference, but you also need to have a physical location. That is for both membership meetings and board meetings. You'll see throughout these slides that there's a bit of a deviation between membership meetings and board meetings as far as the requirements go for video conference notice. All in all, they're pretty much the same. You need to tell the members where the physical location is and how to access the video conference if they're going to access that, or the dial-in telephone number, rather than attending that conference in person. Things to keep in mind: you must record and maintain the video conference recording for 1 year minimum, right? That is if you would hold the conference by video. It's not if you are recording for purposes of taking minutes for your meeting, right? This is a real-time video conference. My members can log in or call in to participate in the meeting. That itself is now an official record of the association for the purposes of the Condominium Act. Finally, you must post the meeting video on the website for the association via hyperlink, right? So be aware of that as well, so that members can access and click on that and then join the meeting. Finally, 718.112 was specifically amended to explicitly provide that board meetings can be in person or by video conference. And it further directs the division to adopt some rules regarding video conferencing. To date, it doesn't appear that the division has adopted those rules yet. They oftentimes take a little longer to respond to the legislative directives that they're provided in our state. But that's because the division is severely underfunded and understaffed, and so it just takes them a little bit longer. As soon as they promulgate those new rules, we will send a blast out to all of our clients. And so everybody that's participating today, if you're on our constant contact list, then that means you got the invitation to come here. You will be provided with an update and a link to those rules. And as far as any of these legal updates go, our clients do know we usually provide a legal update at least once a year, if not twice a year. Sometimes there are some fixed bills that come in quicker than anticipated. You guys remember SERS and Milestone? That was an example of something kind of coming up before the anticipated legislative calendar because it was a life, health, safety issue. So our firm will always remind you all and provide notice of these legal updates in addition to teaching these fun classes. So we really are happy that you're all here today, both in person at our St. Augustine office and with us via video conference. All right, let's go to the next slide about member meetings and condominiums specifically. So previously, you used to be able to have your meeting for your condominium either in the county where the condominium property is located or within 45 miles of that property. Now they've kept the county requirements, but they've reduced the mileage from 45 miles to 15 miles towards the condominium property. And I think this video conferencing option also kind of goes hand in hand with this requirement to lessen the mileage, if you will, because hey, we should be able to all kind of keep towards the condominium. And if you can't make it there, then you can attend by video conference. As long as you're providing that as an option for your members. So again, this is very similar, if not the exact same as board meeting requirements for member meetings of condos. You're authorized to conduct a video conference for the members if a physical location is available, if a quorum of the board is present in person at that meeting, and the video is recorded and maintained as an official record. Everyone keep that in mind. There's also a new amendment to 718 that specifically authorizes video conferences for the budget meeting. There's also a reference to having video conferences by committees, right? Because if a committee conducts a video conference, then that is an official record of the association that must be maintained. Ergo, can the committees have video conferences? It would have been nicer if they explicitly said that like they did with the budget meeting. But that's something to keep in mind, and I'm sure that will be addressed later on as well. There's also been some new membership powers that are provided. One of them being that if your association has yet to adopt online voting, which has been allowed for probably for about the last 5 years for all community associations in Florida, that your members can now petition the board and say, hey, board, we don't care that you don't want to do it, right? We want to be able to online vote and conduct electronic voting. And so here's our written petition and you've got to accept it if 25% or more of the members petition the board to adopt online voting. For those associations that haven't yet adopted online voting, I cannot tell you how amazing it is, right? It is truly something that makes voting so much easier. We used to have membership meetings that lasted like 4 hours while we were balloting and counting all the votes. Now those same associations with those membership meetings last less than an hour. The online voting people have no idea who's running for the board or who any of those people on the ballot are. And so as far as keeping it neutral, right, I don't know how else you could do that better. And then you just get a little printout. This is who won the election and there are your results. Or here's the percentage of membership approval versus disapproval for amending the declaration. Even for, and I would even say online voting and electronic voting is the most fundamentally changing for amending governing documents. I mean, we have associations that were never able to amend their governing documents in 30 years, now passing amendments to the governing documents because people are able to participate just by taking their iPhone out and pressing one button and suddenly the governing documents are amended. We've worked with a lot of different vendors. They've all been great so far. So, you know, no vendor specific there, but just want to give that a little shout out for all of you who haven't done that or who may be hesitant because now you get a petition from the members that says, hey, we want to do this. It is really beneficial in my opinion. One thing though, it can be expensive, right? That's the part, is paying for it. And think about this, you in no way anticipated having online voting, electronic voting. You weren't going to do that. We don't have the expense for a little association, right? And then suddenly here on your desk is the membership petition. You've got to adopt it right now. Where are you going to get that money from, right? Sometimes the members don't even realize what they're asking for. That could potentially result in special assessment, right? If you now all of a sudden, right now, need to adopt and promulgate online voting. So it might be something that if you haven't done that yet, you might want to get ahead of the curve on it and just get it over with. Online voting can be adopted by board resolution alone. That's what's been allowed for the last few years. And so it's pretty easy. You do have to have very specific language when you adopt online voting. It's statutory. So if you haven't done that, make sure you confer with your association council before you promulgate the online voting notice or have the board vote conducted. So the next change in 718, and I will tell you all, this is to me the worst change, right? And my most hated change. I can't even imagine how many election challenges we're about to have. The ballots, and these are not online votes, right? This is not the one from your online voting company, may be emailed to the condominium. You waive your secrecy, right? But I don't know if the members know that, but it says that they waive it. And the association has to have an email address set up where it needs to receive ballots. And if you don't, you're in violation, right? So condos, this is already applied to you, right? It's already in effect. If you guys don't have a designated email address, where are they sending them? Maybe they'll send them to Ansbacher Law, maybe they'll send them to Vesta, right? We just know they're not going to send them to where they need to be sent. Keep in mind that that is now a method for voting. And imagine, I just conducted a meeting, election the other day, and there was a tie. I kid you not, there was a tie. There were 4 recounts. And one of the directors ended up stepping down from the board in order to not have a runoff election from it. But one vote would have made all the difference there because we had a tie between 2 directors. So if somebody had emailed their vote, right, hypothetically, and that vote hadn't have been counted, then the whole election may need to be redone by DBPR. So it can really change things. Sometimes it won't matter necessarily with election challenges. If, for example, we have one member in one of our associations, and he's an attorney, right? And I always joke and say that I'm the worst member in my condo association because I'm a lawyer who's not on the board or not their attorney. But he's that same person in his association where we represent the association. And he routinely every year does an election challenge, even though he runs for the board and he loses by 50 votes. Only his vote and one of his friends are in favor of him, right? And so, you know, as you can imagine, DBPR might say in that case, well, that one vote that was emailed to the association wouldn't have made a difference, Mr. Member, because you lost by 50, right? But we know he'll still challenge. But things like that, where they did have the tie between the two members, just one simple ballot sent to an email address could change things. So keep that in mind. And again, we've got another directs the division to adopt rules. I promise I will get to you first in the Q&A in the back. Okay. So let's go into the other condominium record changes. You now got a duty to preserve minutes of all meetings, and that's extended to committee meetings. Everybody keep that in mind. That was not explicit before. There is now a specified duty to provide accounting records, including bank statements and ledgers. Before this explicit provision, we always recommended that as a best practice, right? The official record statutes, both for 718 and 720, have those catch-alls that say, and all other official records, written documents of the association. That is typically where that comes into, but now it's specifically stated. All affidavits by the condominium association, again, that's something that we've always said as a best practice. So if you look into the statutes, sometimes your manager may need to do an affidavit confirming they sent the notice or that they've provided the voting materials to all members, different things like that. Those affidavits themselves are now explicitly included within the condominium statute, saying that they are official records of the association. Going back into charging everyone with crimes, which has been a theme of our legislature for at least the last 2 years, because we're all a room full of criminals, everybody, right? These condo directors, the managers, the attorneys, the accountants, everybody that touches the association, they're worried about you destroying records, right? So here's where we come back into this. There are criminal penalties for the managers or the directors in preventing records inspections or destroying records. And it now applies to acts which are done willfully or knowingly or intentionally. Previously, there was also a repeatedly element that is gone now. If you just do it once, you are still subject to criminal penalties. And those can go up to felonies, right? Most of them are misdemeanors, but I mean, we're talking jail time for this, right? So this is a serious penalty. As you can imagine, it has caused quite a few directors to leave their positions just because they don't want to go through the hassle of it, not because anybody's going and burning the records from 7 years ago, right? They just don't want to be subject to accusations like that or have any personal liability involved. I mean, imagine you are a new member of your association, you're in a volunteer position, you're doing your best to help your community, and you just moved into the association. You find out at your board certification course that you're required to take by the state that your association was supposed to keep most of the records for 7 years, and the minutes forever. And you find, after having switched management companies the last 3 times and finally ending up with a good one like Vesta, that there is nothing except what Vesta kept, right? And every other manager, who knows what they did with the records. You, as a condo director, actually have a duty to try to locate and replace those records. I've wondered what that meant since last year, right? How is it not a crime to recreate a record, right? To potentially forge a record, because what does that mean? It doesn't actually explicitly tell the directors how you recreate it versus getting rid of a document, right? It's just as bad, right? If I said, Judge, I swear this is evidence. Well, it looks like the real one per my director. This is what it would have looked like 7 years ago. They did their best to recreate it. I have some problems understanding what that means, right? It makes more sense to me in like, hey, we submitted this to the government and they still have a copy, so I went and got a copy from the government, but I don't think that there's a lot of guidance provided explicitly within the statute. So it concerns me that that's in there. And we don't have any cases about it yet because it's brand new. So finally, website postings are required within 30 days or less. Please, everybody, listen to that part, right? Your minutes for a condo association need to be posted on your website within 30 days of the meeting where they're deemed approved. It is no longer the case where you can say the board hasn't approved them yet, so they're not part of the official records.
That used to be an argument that people could make. Now you cannot do that, right? You will be in explicit violation if you don't have those posted on your website. Oh, yeah, well, thank you, we'll go to the end. Okay, let's go into some condo budget changes. So there are changes for provisions as far as assessment increases in exceeding 115%. One of those things that you need to do now is that you have to provide a budget of what the increased assessment amount over 115% would be versus if you were not to go over that amount, right? The board proposals in excess of that have to exclude any discretionary expenditures, right? Again, what does that mean? We'll find out in some case law. I would say for condo owners, it would not be anything that is towards or supportive of your structural elements, right? And almost everything falls into milestone and SERS if you're the 3 or more stories. So just keep in mind that if you're in a condo association that fits within that category, your discretionary expenditures are probably very few and far between, right? Maybe landscaping. A majority of voting interests can approve that substituted budget above the 115%. So as far as SERS and milestone goes, there were some explicit changes to those provisions as well. SERS reserves may be funded by assessments, special assessments, lines of credit, or loans. Why do we have these changes for SERS? Well, it's because everyone is going bankrupt. The condominiums are terminating. Again, that was a goal of the legislator. If you cannot afford to make the changes needed to update and protect your members, then termination may be the best option for you. There are a lot of associations that are choosing termination rather than foreclosing on all of their owners because the SERS and milestone assessments are too much money. Now, there's actually been provided alternate funding methods, if you will, for associations. As it relates to SERS and milestone repairs or funding those, the association can now borrow money upon a majority of the voting interests, right? That's still a lot, right? You still need a majority. Why does that matter? Most of your condominium governing documents probably provide that they don't just give the board authority to borrow, which is the best thing, right? That you need 75% membership approval or 66% membership approval. And so lowering it to 50% plus one is, of the legislator throwing us a bone, if you will, right? So that's why that was added. And the explicit provision saying that the association can fund SERS and milestone through loans, through lines of credit, rather than just through assessments. That was how most attorneys read this before the explicit provision was added, but now it actually says that. Finally, you can meet the milestone and SERS funding through that line of credit, except for associations within 1 year of control by the developer, bulk buyer, or the bulk assignee. So basically, your developer can't go in and get that free money from the bank and say, we're gonna put that on the association, right? So thank you, legislator, for anticipating that they would certainly do that. All right, let's get into some financial reporting. So they've got a time for financial reporting and delivery to members is extended from 120 days to 180 days. It's still due 21 days after the receipt of the financial report, if not sooner. So I think that this is actually more so addressing the accountants and the auditors and how long they take to give us things, and that sometimes, I'm sure some of you have seen, that you might be waiting on your financial reporting and the clock is ticking and you're trying to get it out, but what are you gonna do? The CPA hasn't given it to you yet, right? All the vendors haven't responded to the audit requests, right? I mean, it is just, we get them, that's something on our list all the time as well. And so thankfully, the legislator did provide a little bit more padding for condominium associations. Directors, though, you must now sign an affidavit of compliance saying, I received the financial reporting, right? And I sent it out to the members. Note that that says director, you cannot delegate that to a manager. You may be able to, Barry might be able to come up with a way, right? It says director right here. Just keep that in mind, everybody, okay? So unless you've got some explicit written authorization managers from your board saying, go ahead and sign that, right? I would want that. That's all I'm saying. There's also a downgrade of financial reporting, that we've always had, but it changed from a majority at a meeting to a majority of all voting interests. That increases the bar, right? So a majority at the meetings, we only have 30 members at the meeting. That means 16 members. If I have 300 members in that association, now I need 151, right? And so that really changes the requirements. Finally, it's still allowed only every other year, and you have also got to do a membership vote every time. You can't just say, and we're gonna keep going on with that one. Okay. We now have explicit authorization from the legislator to invest condominium funds. This has been a topic mostly for HOAs that I've seen the last 5 years or so. Investment of condo funds now allows a board in fulfilling their duty to manage and operate and reserve funds of the association to use its best efforts to make prudent investment decisions that carefully consider the risk and return in an effort to maximize returns on invested funds. And an association may invest reserve funds in one or any combination of certificates of deposit or in depository accounts at a community bank, savings bank, commercial bank, savings and loan association, or credit union without a vote of the unit owners. So everyone keep in mind that this new statute contemplates a lot of consideration as it relates to case law and whether your declaration would arguably even automatically incorporate these provisions into it. Therefore, before you invest any of the association's funds, we would recommend you speak with the association's counsel, because there would need to be an analysis as to your declaration and what the requirements are under your declaration, and whether you automatically incorporate the changes to the statutes within your documents, right? Has anybody ever heard of Kaufman language? Raise your hand if you've heard of Kaufman language. That's what I'm talking about, everybody, right? And then we talk about whether this is even a procedural or substantive change, because you may be barred from doing this, even if the legislator says you can. There is case law called Kaufman versus Scheer. It interferes with all of your associations all the time, even HOAs, this comes up constant. And essentially, it says that unless your declaration explicitly provides that you incorporate the changes to whatever statute that you're under as amended from time to time, those are the magic words, they literally call them the magic words, then you are not subject to different changes as the legislator adopts them, because your owners are bound by the contract, which is the declaration that was originally recorded, right? Unless it's something that's like life, health, safety, or you have to give 14 days notice before a fine hearing, right? Those things are automatically incorporated whether you've Kaufman language or not. So it can get very, very tricky. Go to a lawyer about that before you determine whether you have it or not, please. There's case law about it, even just saying as amended, not enough, right? So keep in mind, then you're subject to 718 up until that reporting date as amended. So there's modified Kaufman. There's a lot of different versions of it. Okay, there's also new reporting to the division. Again, the poor division, they just keep giving them more tasks and then not any more employees or money to do all these things that they're tasking them with. Condos, if you haven't done this, keep in mind that the timeline has already passed. So you need to get on it as soon as possible in order to rectify this. By October 1st of this year, you gotta register and update annually with the division, right? There's quite literally a profile when you go onto the DBPR's division of condominiums where it says log in and register, and then you can go in and you can add this information, right? So you need to have your contact information, a list of all the board members, the CAMS information, the association's website, total number of buildings, units, and aged buildings, identify new construction to the common elements, total assessments, bank information, and CSRS data. Now, I know a lot of you know this, but we almost solely represent associations. Very rarely do we represent owners, only when the association's being very bad, very egregious in its actions. Does Barry allow us to do an owner case? One of those ones that end up on the news, if you will, right? So when I saw this, the first thing I thought of as it relates to doing an owner dispute is I can't wait for them to do that, and then I'm gonna do a public records request to the division and show that they did a material alteration and they knew about it, they listed the new construction to the common elements, right? Because that is one of the places that has the most lawsuits is material alterations to the condominium. So that's what they're asking me for, identify new construction to the common elements, right? I would love to know what that means. Did you rebuild them under certain milestone, or did you change something without membership approval? Because I will use that report from you, director, or from you, manager, to show that you knew that you did that and you did it without a membership vote, right? So keep in mind that this information will be publicly available in the form of a public records request. We are the state of Florida, and so the sunshine shines on everything, as they say. So keep in mind, when you are reporting this, somebody like me, the hungry lawyer, can go and use it against you, right? So you want to make sure that you are not only being honest with what you've done, but if you are doing changes to the common elements or new construction, material alterations, get the membership vote, right? If the members don't approve it, then unfortunately you probably can't do it unless there's a loophole like, it's an emergency or it's required under code. Talk to your lawyer for more exclusions. All right, CAM regulation. So directors for condos, you now have an explicit duty to verify that your manager is licensed, right? You can't just take their word for it. Now you've got to go look it up on the division DBPR's licensing portal and make sure that they are in fact licensed. If it turns out that your manager is not licensed, then of course the association is now explicitly authorized to terminate that management contract. It further prohibits a manager with a revoked license from owning or working with another management firm. That makes sense. I would hope that similarly, if you were a disbarred lawyer, you wouldn't be able to start a law firm, right? I think that that's probably already a rule of the Florida bar. So the CAM may not knowingly act in violation of law, even if directed to do so by the community association. Typically, it's difficult to prove knowingly as an element just generally, but it is something to be aware of because we see a lot of complaints on our managers' licenses for not having noticed a meeting, and then we'll hear from the manager, oh, I told the board, hey, you guys forgot to notice the meeting, you're not supposed to have it. And they said, we're gonna have it anyway. And then you're here under your management contract, right? And suddenly now you've got a complaint in your license. That is the concern, right? And this makes it even more of a concern. What are you supposed to do? Walk out? I don't know. But it's something that directors you should be aware of as far as your manager goes, because even if you might want to have that meeting, your manager might end up getting in trouble for it, right? And there's nothing they can really do. They're kind of in a different position than you, and they're being paid to be there. So just keep that in mind that, it's not, if it's a real emergency and you have the provisions for an emergency meeting, that's something different. But if it is, hey, we could really renotice this, you make sure that you want to do that, because I can't tell you how many times, we've had to deal with complaints in that same aspect, right? And it's difficult for the association. And oftentimes it could have just been avoided by having a meeting 2 days later. So, all right. Contracts with your management company now must specify that the CAM must abide by all professional standards and record keeping requirements. I actually just reviewed a new management contract and saw this provision for the first time in a management contract, which was fun. And we said, check, there it is. The management contract may also not waive or limit professional practice standards under the Management Act, which is 468. Okay. They kept going after the managers, right? Because they don't have enough to do already. They needed to give them more things to provide. So it expands minimum management duties to condominiums. That means that you have to attend one in-person member meeting or board meeting annually. They want to see who the manager actually is in person. You've got to provide the name and contact information for each manager representative assigned to the community association. That's got to be on your association website as well, right? And I've had a lot of questions. Is it really everybody? We've got 5 people here. We've got 8 people here. This person's here 1 day a week. Yes, it's everyone, right? They all have to be listed. You also have to put the hours of availability for those workers and the summary of their duties. So maybe it's the A or B liaison. This might be the compliance chair, right? The compliance person, whatever the managers call themselves, you know, they all have different titles. Just like the lawyers, right? We've got all these crazy titles. And then finally, you've got to have that required disclosure posted on the website and updated within 14 days. So we can't say, oh, we put it on there 2 years ago and now we have a different management company. If you have a change in management, it needs to be updated within 14 days. The management contract must also be furnished to members upon request. It's always been provided for as an official record. Now there's an explicit provision that you've got to provide it upon request. So that would be arguably sooner than the 10 working days of being asked for it. Very similar to the language as far as providing the governing documents upon request, if you all are familiar with that recent change to 720 last year. So that's kind of how we're seeing that be increased burden, as in right then and there or within that day, you'd be providing that management contract, right? Just like you would the declaration. I don't really need to look for that. I know where it is. It's right here. Okay, get more into conflicts, right? We have an explicit definition now for what compensation is as far as anti-kickback provisions in your management contract goes. It limits anti-kickback to money or monetary benefits received from or financial interest in product or service providers recommended to or used by the association. That is the definition, right? So it's not just, hey, I get money from this association or from this, you know, vendor for this association. It might be that you get other benefits, right? Other kickbacks. They're saying that it's not simply just a financial interest in that vendor. The duty to bid for contracts under $2,500 with unaffiliated providers is not required as long as those services are disclosed in the management contract. So everyone make sure to read your management contracts. This really matters, right? As far as vendor selection goes, and making sure, hey, this might be the best vendor for our association versus the one that our manager knows, right? The one your manager knows might be the best one for the association too. You just want to be aware of which provisions, if any, which vendors, if any, your manager does have a relationship with. Finally, it eliminates the duty to disclose conflicted contracts at subsequent membership meetings. So previously last year, this is a brand new change. If you entered into a conflicted contract, then at the next membership meeting, you actually then announce that and say, hey, members, we entered into this conflicted contract. That doesn't have to occur anymore, right? You still have to do the special notice requirements for a meeting where a board is considering a conflicted management contract or a contract with a director in a CAM conflict. You have to put the description of the proposed activity, right? So we intend to approve a landscaping contract that is a conflicted contract because the management company receives, you know, $500 every time they sign up with this vendor, right? Or because the vice president is the owner of the vending, you know, service, right? They own the landscaping company. And then a copy of all proposed contracts. So you've got to explicitly provide that to the members now and have that on the notice. Again, make sure you speak with your counsel about the notice requirements for this one. This is sure to be a highly litigated area. So you just want to make sure that you're doing the notices right. Other provisions that were given to Milestone and SERS, and these are under 553.889. The other changes we went over earlier were under 718. So this is the structural integrity reserve study component of it, if you will. It extends SERS deadline by 1 year. I know that's so annoying, right? They kept saying for the last 4 years, next year is the deadline, next year is the deadline, get it done, get it done. They've given you another extension to complete SERS if you have not done that so far. The biggest change that we saw this year, and probably the most important and most annoying change to me, is that SERS and Milestone only applies to buildings that have 3 or more habitable stories, right? There's also this 3 and 4 family exclusion within CERS. I can tell you, I have talked to so many building departments now about this 3 and 4 family exclusion. I don't think any of them have a real grasp on what that means. I have seen too many associations be denied underneath of that provision, and they say, no, it's 3 stories, we don't care, there's only 3 members in this bill, right? Because you have more members than that in your other buildings. I've had a lot of associations try to argue that, it hasn't been successful yet. That habitable is the part that everybody is harping on, right? This is the biggest change. Why? Those condominiums that had, for example, a garage on the bottom floor, right? Or somewhere that you could not live, were previous to this legislative change, subject to CERS and milestone. Now, if they don't have a habitable story, they're not. What if you listened to the legislator, you thought, for sure, we need to be in compliance, this is life, health, safety, we've got to do this, we're assessing our members, and you acted accordingly. And now suddenly, none of it's required, right? There are more associations than you can imagine that are in that boat right now, and there's not really even explicit direction from the legislator about what you do now. Do you just tell your members, hey, never mind, right? And hope they don't change their mind next year? There's also a lot of controversy with what habitable means, right? Habitable means different things in different contexts. There is habitable under the Florida Building Code, right? There is habitable under the Fair Housing Act. I had an association that had occupancy restrictions in their declaration. The declaration was, 40 years old. And it said, we have 2-bedroom condos. No more than 6 people can live in the unit, right? Well, we had, of course, a tenant that had 18 people living in the unit, right? And when the association sent a violation notice, the manager listened to the directors, sent a violation notice with too many people in there, it's causing ruckus, right? The neighbors are complaining. They went to the federal government, said this is fair housing, right? And you can't do that, association. And so I spoke with the housing investigator, and she explained to me that under the Fair Housing Act, when they're determining what habitable means, they look at all areas in the association's living space where you could sleep, right? So in the condo unit, you could have at least 4 people in this kitchen. That's what she told me. At least 4 in the kitchen, right? We could have 1 in the bathtub, 1 near the toilet. We could have 5 in the living room, right? Let alone the bedrooms. That is habitable to them, right? So can't I live in the garage? Isn't my first floor habitable, right? Under the federal government standard, it might be, right? What about when you sue your developer for construction defects and you say you broke the implied warranty of habitability, right? And your developer says, what do you mean? They're all living there right now, right? No, that's not what that means. If we had breached that, none of you would be able to live in your association. Breaching the implied warranty of habitability is almost in every construction defect lawsuit, right? That is a standard practice. Again, different definitions will lead you to different results, and we don't have one here yet. The building code, the Florida Building Code provides that if, for example, they issued a statement recently about this exact legislative change in it, I think it made things worse. Everybody was much more confused after it. If, for example, there is a commercial area that provides for a bathroom and sleeping quarters, but there are no residents and they don't sleep over, then it is still commercial and it's not habitable. If there is a sleeping area and a bathroom, but the residents do sleep over, then it is habitable, right? If there is only a bathroom and there is no sleeping area, then it's not habitable. Again, completely different definitions, right? So there's probably going to be a lot more change coming as it relates to this. I wouldn't be too confident if you're one of those associations that falls into the category of now falling off the milestone and CERS to go ahead without speaking with your legal counsel first, as it relates to adjusting your assessments to account that you're not part of that anymore. Ultimately, the building official will determine whether you are subject to SERS and milestone. That is the authority that would enforce against you. And so when our clients in the past have come to us and said, hey, are we subject to it, right? Under the new laws, and I read them and I say, yes, client, I agree with you. Under this, you shouldn't be, right? But let's ask the building official, because the building official is the one that's going to fine you and say that you're not, right? Let's see if they agree. And they don't, they never do, right? They say, no, 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 you're subject to it. I haven't seen one yet that says, no, we're not including you in there, because imagine what's on their hands if they're wrong. And then you don't have, oh, no, this one didn't, over here didn't need the structural integrity, right? I determined myself that it wasn't subject to it. You can imagine the risk that's involved in that as well. So there are a lot of factors that go into this beyond what does the statute say, right? You also have a temporary pause that's now allowed in reserve funding for 2 years immediately following a milestone inspection. I guess to allow everyone to catch their breath, that's the only thing that really makes sense to me as far as why are we providing this 2-year gap. Then you've got a new requirement to the building officials, so that's who the local officials are in this case, to adopt ordinances, essentially to allow it to enforce against you, right? So not only is this a breach of statute that a member could potentially sue the association for, now it would be also allowing your building official to go and enforce SERS milestone against you, and say you're in breach, here's the violation provisions, you are now fined or whatever it may be. Finally, you've got to have a director. Again, guys, it says explicitly director. Most of the time it just says the association, right? Here it says a director must sign the affidavit to receive a completed SERS study. That way they can't say, oh, I never got it. We don't know what happened to it. We know who got it from the building official, from your engineer, or your architect, and then who was supposed to send it out to the membership, right? More changes, and this one makes a lot of sense to me. So if you've got your SERS specialist, right, your milestone specialist, your architect, your engineer, they need to disclose if they are going to bid on your work, right? Imagine, and this has happened, right? This is what the change is. I am the engineer and I get to say everything that's wrong, right? Luckily, I own a company that can fix all these things. You can imagine how I could have padded my pockets if I was the ethical engineer. Same with an architect. Now there's an explicit provision that says they have to disclose that. And if they don't disclose that, then they cannot bid on it, right? Deferred maintenance expenses were previously 10,000 and up. They've upped that to 25,000. Again, that's trying to give some condo associations a little breathing room, because if it was a deferred maintenance expense that was over $10,000, then you had to fund for it under SERS and milestone. Now they've raised that to 25,000, right? So not a lot, but it's better than nothing. Again, we've got the DBPR being required to create a standard form for SERS. It's not been done yet. We'll let you know. SERS reserves, if they're segregated, they can be pulled without a member vote. Again, that really makes sense in the idea of we've got to suddenly fund for all of these required items, even if initially set up our condo only did half of them. And so it allows you to use that same line of credit, the loans, even if you have your assessments available as a fund in your operating account or in your reserve account, you can use it all together and pool it. Finally, the SERS study must consider the funding methods. So you've got to say how you're funding it, whether it be a line of credit or a loan or special assessments or raising your annual dues, raising your monthly dues, right? You've got to explain how that SERS will be funded. All right, guys, there's not a lot of condos that even fit into this category. It's a very niche area, but it is a big old change that came to our non-residential condos and our mixed-use condos. How did it get here? There has been some case law, a lot of fun. We have one of these lawsuits going on right now in St. Johns County. And it's based on the same type of case law that is at play here, right? So what are non-residential condos? Well, that's a lot of the times commercial condos, right? Office units. So now you've got a specific exemption with non-residential condos of 10 or fewer units for turnover, right? So there's some automatic provisions in here as it relates to turnover that allow these non-residential condos to act on their own behalf, if you will, right? Condo insurance was also amended in 718. The association, and this is probably the most fundamental change that this provision of the statute was changed to, is that you've got to, I think I skipped one, sorry. Yeah, you've got to determine the replacement cost at least every 3 years, right? Everybody, at least every 3 years for insurance purposes. Adequate insurance is the full insurable value or the replacement cost and may be based on an independent insurance appraisal or update. So everybody just keep that in mind as far as it relates to doing your duties and obtaining insurance for the association. Now let's go into the mixed use buildings. I do believe this is the last slide and we'll go into some Q&A, which will be fun. So there was a fun case called Brickle One that came out, I want to say early this year. And it was about a condo that shared a building with a hotel. And the condo was on top of the hotel. The hotel had its valet, as you can imagine. The hotel wanted to look nicer than it had originally been developed. They wanted to bring more people into South Beach, right? We've got to be the best thing on the block. The problem was that hotel was not part of the condo. The condo was much bigger, had way more members and way more square footage of the building that they shared, but they had no rights. They couldn't inspect documents. The hotel got to set the budget for the condo. They said, this is here, just pay the money. You owe us $40,000. We don't have to tell you what it's for, right? And you can't inspect our official records because we're not a condo. So you're not even a member here. We just share a building and we have control over this building. Luckily for us, you bought into it. It's been recorded. That's the contract that you bought into. So, too bad, so sad, condo association, right? And the court said, no, that goes against the condominium concept, which is, I mean, I can go down a rabbit hole with you guys about what the condominium concept is, right? But essentially, the unit owners were being deprived of their rights to their condominium and the allocation of their ownership in the common elements by virtue of the fact that those same common elements in part had been provided or given to the hotel to control, right? And we're just subject to whatever you say. That's not fair, right? So that is what happened. That's how we got this new change this year. So the non-condominium portion of the building must provide annual financial data for any shared facilities. It's due within 60 days at the end of the fiscal year. It also subjects the non-condominium property owner to the jurisdiction of the division and to enforcement and penalties, which are not specified. So if the division ever answers, then they might get mad. And it provides condominiums a 60-day window to challenge the apportionment of costs under 72311. That is the pre-suit mediation statute for HOAs, if everyone's familiar with that, right? Keep that 60-day timeline in mind. Arguably, if you miss that, and you're one of the associations that has this, right? You've got commercial units on the bottom and you're on the top. We have a few associations that have that. Then you are subject to the same type of idea, right? Okay. Thank you again, everybody. And thanks for coming. We do have the question and answer period that we're going to get into. I think Barry might be joining us again. I know he pledged to Rhiannon to join us for the Q&A as well.
How did you hear that? Yeah. So I have the online questions and I figured we can address those. And Cream, did you want to come up here? Or just... Yay, thanks, Rhiannon.
I did not know I signed up for any of this.
I figured if it's a management company, you can chime in. If not, but let's get a few of those online ones kind of taken care of. And then that way you guys have the floor. Let's start with. In terms of the investment of condo funds, does this change if it's a nonprofit status if they invest?
No, you can't. Yeah, you can't just become a for-profit association by suddenly making a profit. You do actually make a profit already in the form of your assessments. So that's not exactly the differences between, the corporations without getting more into that. So no, don't worry about that. If you are investing your funds as a condominium, you are not suddenly a for-profit corporation in the state of Florida.
This one is, we have a current management contract with Vesta.
Yay.
Does this contract need to be updated to comply with the 913 changes?
My answer would be to get with your CAM. I'm not sure when their contract was executed. It's easy to add an addendum if it's not in there already.
Woo, okay, and then we've got some in the back too, actually, so let's grab one of those. Who, sir in the back, you've been waving your hand.
Yes. Okay, the first question I had was in terms of, is there any, word as what they're going to do for those of us who did put our information out there, whether there's destruction of that data, so that way we're not being, used in some other litigious way from the government that we put all our.
I am not aware of any statements from the federal government about what they're going to do with your information. But what I've told people in the past to make them feel a little bit better is at least they already had it. You know, they've already had that information, so, yeah.
Nothing new, that's confident.
Yeah. You could always have your identity stolen, right?
So the second one I had was regarding email voting, because I'm not having the email there. I've been in IT for 36 years. I have had my own personal email address sent back to me from other providers who have, they just can't reassign their email, just by somebody doing real good with the headers in that. I don't, what kind of security do you have? If they're going to accept email votes and those types of things, that someone in your community doesn't actually sign that email, because they're listed, if you're in our directory, someone wants to steal a vote by emailing something for somebody else. You've got two people with good votes for it, hey.
I didn't even think about that. Then another peril. I mean, we needed the technology guy to tell us, but yes, I can see it too. I mean, I have no idea how you would stop it.
Very
Yeah.
nervous about using email for those kind of things, if it's not a secure platform.
Yeah. No,
I would agree. I've never believed that emails are a secure platform, but I don't think that they've thought that far ahead.
I agree. Laura?
Yeah. Again, we have, elected to do online voting, so we've got people that signed up for online voting and electronic notification.
Mhm.
That list is, official documents, so somebody could ask for that list. What on that list needs to be redacted? Like, should we redact the email address?
So the email addresses, this is a funny one. So email addresses, when you're disclosing records to members, are supposed to be redacted. The membership list is an official record of the association as well. And if the owners are putting their information out there to be part of the list and you all send out a directory, that's the pertinent part, right? If you send a directory of members to the other members, then you have to provide it. But otherwise, redact that information like it says.
Okay, but we have all that on our website. They can go in and put all that information they want in, so they've already authorized their email to be addressed, so any member can go on there and look at our directory.
Oh, yes, then that you have the directory,
Correct.
yes.
But documents that we have, okay, the street address, does that need to be redacted?
No.
Just name, address, and,
Not the name, just the email address itself. So like if somebody does an official records inspection and they want a copy of an email between the manager and a member, you would redact the member's email from that message, right? So it would still say John Smith, but it wouldn't have like in the parentheses, johnsmith@gmail.com.
but we need to protect members' email addresses if somebody asks for those.
Yeah, even though it's available on, right? It's ridiculous, yes.
There you go.
You got one, go ahead.
Is that the same for HOAs?
It is not.
Not yet.
Yeah, it will be. You, as far as, we're catching up the condo statutes, it's usually like within 2 or 3 years that they'll do it. I've heard so far, Barry sent out a blast the other day that said that there are no big bills anticipated from the legislature this coming year, which would be fantastic. Because as you all probably know, we've had 2 years in a row with major changes. So I'm hopeful that it won't happen this coming year. But, you know, they said that last year too. Here we are.
So if we get a records request from a homeowner, we can go ahead and redact the email address.
The information is for 720 is listed within the official records statute. This is a 718 thing with the email addresses, but it's probably coming to 720 soon.
So,
Now you,
when, at the beginning of your presentation, you said it would take a little while it gets to the HOA. Would you think, or would you recommend that we start following some of what?
Yeah.
Yes.
This-
Yeah, go ahead, yeah.
Yes. The client that I'm currently working with, they have been represented by Ansbacher for many, many years. I was so blessed to come in. They had already started, but being proactive and taking on a lot of the condo law. Because, and it's really made our lives easier now, because now that those things are in effect, we're already on top of it. So I would highly suggest what you can get ahead of, do so. Because it's usually sure to follow that HOA follows suit of any condo laws. Similar, maybe not exact, but similar.
So does this apply to like resident rectories and things like that?
So yes, this is where it comes in between 720 and 718, which is the issue with
okay, but I
your
remember the
association, yeah.
720 question.
Okay, well, what I want to clarify with yours is, if you're a 720 that has 718 members, then you are in this really weird area, right? That you've got a provision that the condo members under 718 are supposed to have their email addresses redacted, and in your 720 HOA, you don't have that same extensive provision, right? So what should you do? The best practice would be to just redact it all, right? To have the email addresses. Technically, if you're the 720 and it's being sent to you, I would argue if somebody challenged that we don't actually need to do it, right? That just by virtue of the fact that these condo members are part of our 720 association, they don't have the same rights, if you will, right, as a 718 member that's not within a 720. But this is kind of the area where one needs to catch up to the other. If you fall within the 720 and having 718 members, that would be, you know, part of the redaction statutes explicitly for email addresses. I would recommend just redact all of them. I think it's easier that way.
Okay.
Yeah. Mr. Day?
Question.
Oh,
The park covenant says that we have restrictive parking on the streets. But we're not in a community that's, you know, gated.
Mhm.
It's on a county road. Can we still follow those guidelines, or do we have to go? It's a county road that it's allowed to be parking on the streets. We are kind of a narrow winding road.
yeah, so let me give a little disclaimer first, right, that we can't give explicit specific legal advice, right? And this is where that Kaufman thing comes in that I was talking about earlier, the Kaufman v. Shear. It's very dependent, and Rhiannon knows that she's an association that said, nope, doesn't apply to us, right? We're not doing it. And we have a few clients that did that. Recently, in the last 2 years, there was a change to 720 that said that you can't enforce parking provisions in that way unless it actually fits within a commercial vehicle, and that's like bigger than UPS truck, bigger than a school bus type thing. Yeah.
So if somebody has like a Cintas truck that they, you know, drive, you know, no, on their not. So they leave the work and the property. Is that?
So again, this is really dependent on your actual provisions in your governing documents and whether you have Kaufman language. And then further, whether your association is going to say, hey, we're putting the public on notice by filing a notice in the official records that we are not abiding by HB 1203's provisions as it relates to commercial parking. So this can't be answered, unfortunately, without me actually looking at your governing documents. There is a potential that your association can enforce those restrictions. And then whether you actually want to, right? Rhiannon's got an association that has enough money and they've got a guy on the board who's like a financial investor and it's just made them so much more money by investing their funds that they have enough money and power to do that. If you're a little tiny association with 20 homes, 50 homes, you might not be able to bear the lawsuit, right? That could come from doing something like that. But just know that we've got a lot of associations throughout the whole state that really are upset about that law. And they are actively litigating already to try to make it so that it is not part of 720 anymore. So there may be a change in the next few years through the court system that say that that can't be done. The reason for that is that there is actually a contracts clause within our Florida Constitution that says that you can't infringe on the free will of parties to contract with one another. Again, we go back to, in Florida, your declaration is seen as a contract between the parties. And so the legislator saying, no, 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 not that part's bad, right? We're not gonna make you do that anymore, you can't do that. That arguably, and I think actually validly, is an infringement of the right to contract. And so 5 years from now, this might not even be a topic. They might say, no, that was never allowed. Mr. Day, go ahead.
Yes, timeshares, not said very much about it anymore. For the last about 7 or 8 months, I've been getting a lot of investment packages. People, want to invest in, not paying, building credit, maybe today, timeshare. But I haven't heard anybody talking about governments and timeshares. And how does that work? Is that a separate category?
Oh, man, timeshares are their own thing completely. Have you ever done a timeshare?
Thank God, no.
Yeah, right, like, don't do it, okay, first piece of advice, right, not non-legal advice. I wouldn't do it, they're their own category, could have their own class. I have done, I think, 2 timeshare associations, it looks very similar to a declaration, except there's like another part of the declaration that has the whole financial scheme, if you will, and how it's divided. There's a whole category of lawyers that popped up just to defeat timeshares and to sue on behalf of members who bought into timeshares. Not to discourage you, but for everybody that's online, there was a question from the audience about timeshares in general and what their declarations are like.
But they are better. To answer.
Properties that are being salted, residents come in and work.
Oh, yes.
I'm thinking about there's a problem.
Nope, timeshares still exist. There's still some of them that are out there. We even have a few cooperative associations, some 719s, with the 721s, and not as common in Florida, but they do exist and they've got their own laws. If you guys are on, anybody on this, are in this room or on this Zoom from a timeshare or cooperative, these laws did not apply to you.
Yeah, to answer your question, Mr. Day, they are timeshares. So we, as your community manager, it's the same governance to some degree. They are governed under their own chapter, and you are required to have some sort of legal management.
Okay, do we want to do another online one, Paula?
Go for it, let's do. Can you kind of differentiate online votes and email ballots?
Oh, man, online votes versus email ballots, okay? So online voting is when you contract with a vendor, right, like Vote Now. And,
Oral.
Yeah.
Yes. And then that vendor, in association with your management company and sometimes your legal counsel, will create the election or the annual meeting packet, whatever you're voting on, promulgate it to members. There's an instruction packet, and then the members go and vote on that. Right, will you explain more what that packet's like? I know you've done that before.
Oh, yeah. I mean, essentially, you are distributed your own personal pin, if you will, your own voting number. And then you vote via online instead of sending a ballot. But your packet is the same, your annual meeting notice, you get, your first notice, your second notice, however your documents are. And then it's just kind of more of the instructions on how to. And it negates having to mail physical ballots or drop off physical ballots.
And so, the difference then with emailing a ballot is rather than using the online voting that's right here available to me and much easier to use, I chose to get a physical ballot. Maybe I even made my own. It really doesn't say you can't do that, which is my big problem with it too. And then I went ahead and checked it off and then I emailed it to the manager, right? That is the problematic one. I'm not as concerned with electronic balloting as I am with emailing a ballot. I don't know, have you guys ever seen the proxy wars where people start doing making their own proxies that are different from the association's proxies. That's what I see happening with this ballot thing,
I agree.
right? This is who I think should be on the board, right? You know,
Yeah,
right? Or this is what I think the government document should say, you know, so we'll deal with it as it comes.
This one's from Leo. It says, can you explain how interest income from reserves can be used? For example, 4% earned on 100,000, reserved for paint. Also, how does it show on a financial statement?
Okay, so this one is definitely one that you want to, if you're reserving your funds and you don't have someone like Rhiannon does on her board that literally professionally has a license to do this type of thing, that you want to talk to a financial advisor. This isn't just a lawyer thing. It's not lawyer and manager, right? You want somebody that knows how to invest. We would need to look at your actual reserve study in your governing documents to know what you can actually use the income that's derived from those funds for, right? And whether you have any specific exclusions related to the use of that money. But it's something to definitely keep in mind. And then as far as investment goes, and I think Ray can speak more into this, her association invests in things that are backed by government, right? And so it's not a risky investment. It's not like, hey, I met this investor from Shark Tank that said that if we invest our reserves, we're gonna make so much money off this Snuggie, so I did it, right? And you would have made money off the Snuggie, right? But things like that are probably not allowed, and I would discourage them.
but, and also to answer that, or to add to that, you, how does it show? It's always its own line item on the financial statement. So it would be, it could be coupled by other, investments. But additionally, it would be its own line item of interest.
This one was probably when Barry was speaking, but it says regarding selective enforcement, if the association is having a budget crisis and does not have money for parking enforcements, do they still have to find a way to issue warnings, fines, or towing?
Oh, man, so, Ray, you wanna talk about what selective enforcement is?
Oh, boy, it's my biggest pet.
Yeah. Everybody's selectively enforced, no,
Yeah.
that's what they say at least, yeah.
No, I guess I'm not really sure what their question is. Basically, they're asking if there's an alternative route instead of enforcing.
They don't have money to, I think what the person online is saying, if they don't have any money, right, we're already in a deficit. How can we hire a manager or a lawyer to enforce these provisions in our governing documents when we can't even afford to operate our association? Well, first thing you need to do, I think, is operate your association, right? That would be the main goal before you go into bankruptcy or receivership. Next, you need to look at funding the things that you need to do. So it sounds like you need to increase your budget or potentially do a special assessment, which obviously no one likes. But if you're not able to fully float what you need to do to operate, then that is a bigger concern to me than anything else. But yeah, you could potentially have a selective enforcement. If the association doesn't operate for 5 years and doesn't enforce against anybody, you better believe that the first thing I'm gonna do when I represent that member is say that they're selectively enforcing against them, right? One time I had a selective enforcement case and I created a graph of every lien that the association in its 23-year history had ever recorded against all members, and the price of the lien. And I was trying to show the judge that our clients, the debtors, right, were being selectively enforced against because their lien was only for $3 and everybody else's lien was for like $500, right? And the judge loved that graph, right? Look, you can't usually prove selective enforcement, but look, I'm this outlier over here statistically. Isn't this the selective enforcement, right? Opposing counsel hated me. But that's the idea, right? You're treating me different than everybody else in the association. Why are you treating me different? I had a really funny one in Ray's association the other day, where a lawyer for a corporate member, right, so an LLC company said, we think they're selectively enforcing against our client. I said, you should go ahead and search their name in the court records and see how many lawsuits they filed in the last 30 years and tell me if your client's being selectively enforced against.
Yeah.
He was, don't you just forget that one, right? So oftentimes there's an easier way to prove that it's not happening versus the member proving it is happening. Here, let's take more in audience.
Going back to investment, interest earned. We have pooled reserves, but on our balance sheet, the reserve interest is a line item with the GL.
Mhm.
Yeah.
So am I correct in my understanding then that that amount of cash, which it is unobligated?
We can't say without knowing what your documents state. That's the part with Hannah, that where Hannah said.
I mean,
It would be based
It's
upon
supposed to be back
how
in
you're allowed
reserves,
to
yeah.
spend it.
It's part of the reserve total,
Right,
but it's not attached directly to any specific asset, like.
right. It's just showing as revenue.
Right.
However, I can't say how you can spend that money without knowing more of your documents.
It sounds like what you're doing is right, though. From what I see.
I mean, we can spend that money.
You can
You
spend that
can
money.
spend
yeah.
it.
But only in reserve.
Yeah, the interest accrued on reserves
Right.
goes towards the reserve items, yes.
Right.
Yeah, but you can, like she said, list it in a different line item, that's perfect.
You have a question?
Yeah, Susanna, the person next to you, she was raising her hand a couple times.
She is.
Okay. Oh, okay.
In the back right there.
A question goes back to enforcement. If you have, in your declaration, your covenants, certain rules that you don't enforce or ever enforce for years. And now someone, a homeowner has brought that to the forefront and you now enforce it. Is it considered selectively enforcing something now? If you've never enforced it before, if you never enforced it for years, have you abandoned your right to now enforce?
This is actually a really fun case, and it's called chattel shipping, CHATTEL, chattel shipping. And it says that if that happens, as long as the association sends out a letter that says, we're gonna start enforcing this rule, then you're fine.
Yeah.
But if you don't do that, then yes,
And then stay consistent.
yes, that's the bigger part, actually. Okay, the back over there.
This one's for CE, if we have a board member that's not taking advantage of these classes and going out to a for-profit provider and paying for it, can the association reimburse that homeowner?
Oh, no.
No.
No, you know what the funniest one I got a question and I'm wondering if it's true, not if it's true, but I guess what they'll do with it. Now that board members for condos have to attend the annual meeting and have a forum, right? Does the association pay for their flight home?
No.
Right?
Negative.
Isn't it a business expense, right? I mean, look at these arguments that people are gonna come up with, right? But anyway, I like that one better than the CEUs. I definitely wouldn't pay for that.
Yeah.
Yeah, especially because there's braces spent.
There you go. Just an off the wall question because, our community, the percentage of live-in homeowners versus homeowners that are 24/7 renting their properties out for everything, and we have some people who are renting with electronic means, so they're not abiding by the 3-day minimum law. You must have this rented within total of 3 days minimum. You can't just rent for a day.
Mhm.
And we have tremendous turnover problems and other things that are starting to happen. Is there anything that's coming down through the legislature about to try to give, because the homeowners who live there we're struggling with certain issues that the rental community, if you will, and other action in our community, they're gaining more and more numbers and they're not really caring about
Yes.
people who live there.
It's a common issue, and for everybody that's online that didn't hear the member in the audience. He asked what his association can do, or what any association can do, where they're having a renter issue or a short-term renter issue, and if there's any legislative fixes available for that. There are Brands Association did it. You can pass a short-term rental amendment. It requires an amendment to your declaration, which is typically the highest threshold for changing your documents. I'd have to look at your documents to determine what that is, but it's usually like 2/3 or 75% of all the members. And if you do that, and you're within the provisions under, short-term rentals within 718 or 720, then you can, change it. Depending on if you're a 718 or a 720 and what the length of, stay is, right, what the minimal short term is determinative of whether that will apply to all owners or only the owners who voted into it or subsequently acquired title. So that's something you have to talk to your lawyer about too.
I have an online one. If the board wants to change management companies, is a notice meeting required?
A noticed meeting is required anytime that you're entering into a contract, so in that sense, if you're switching management companies, you're signing on with Vesta, Rhiannon sold you today, right? You do want to do that at a noticed meeting, right? And other things to keep in mind, as with any vendor contract, make sure that you look at what the termination and cancellation provisions are, because there could be a penalty for canceling your contract, that you guys might need to be aware of if that is what you're going to do.
Can I ask a question about CEUs again? If we have a board member who is refusing to do his training. And what action does the association have in order to enforce that?
So this is a really delicate one, right? And for everybody that's online, what we just had a member ask, if we've got a director on an association hypothetically who's refusing to take their required course credits and obtain their certification, this does happen, right? So legally, I'm gonna give you a legal one, and Rhiannon's gonna tell you what is the best way to kind of poke at the board member and get them to do something. So legally, the statute says that they're not on the board, right? Until they cure that, and then they take the class and then provide proof of having taken the class. What I have seen in the past from challenges, and why we always warn our associations not to be the division, is that the division says, we decide who's eligible, we decide who's been certified, you don't, right? Association, you come to us and say, we've got this issue, this is what it is. Oftentimes, though, this can resolve in a much easier way just by speaking with the board member or bringing it to a head that way. So I'll let Rhiannon kind of explain her best advice for that.
Well, and honestly, my personal approach is just to reach out in more of the first time that I reach out, the management should reach out and just let them know that our records indicate we don't show record that you have taken agency. Please note, you are in, you're violating. If you have those, can you please provide them? Otherwise, here are some upcoming events. To make your effort, try to get them to do the right thing. Then, you definitely want to talk to your president, the management would definitely want to speak with the presiding officer, whoever that might be, the president. Let them know that they're not, in compliance. And usually the president can have a in-depth conversation with that person and kind of explain it. Two things either happen. One, they resign from the board or they go for the course. Otherwise, worst case, like Hannah said, you'll have to let the division know that they're out of compliance. And this is where, don't take it out on your CAMs, but your CAM has that obligation as well to let the division know, because their license is also, a factor.
I am the board, president of the board, and I've sent out notification and copied our, manager on it. And it's like nothing ever happens.
That's unfortunate.
And he was the former board president.
Well, we've seen an uptick. I'm sure all of you CAMs and everybody else and board members, we've all seen an uptick of that, they've been on before, but now with these requirements, a lot of people work full time. I mean, I feel for all the directors that have these requirements because you don't get paid as it is. It's a thankless job. So we don't exactly agree with it either, but it is the requirement to be on the board. So in that case, I guess I would state that you're no longer on the board, given you haven't fulfilled your obligation. And I would report it to the division like that.
See, the thing too to think about.
And that leaves no thing in the board.
Yeah, you can appoint someone to fill the vacancy until the director cures the issue, right, by taking the class. I think, like Ray said, hear all the different classes. I've had associations where this is happening and they say to the directors, hey, actually, we are now required, because you all haven't taken this, we're paying out of pocket for Ansbacher Law to teach us a 4-hour class. We're gonna have an attorney-client meeting and do it. As an expense of the association, and then we know that everybody was there the whole time. We've had that happen before too, so if that's within your budget, that's another option as well. Although it's obviously expensive, it's a way to force compliance.
Well, is there any way I can get a list of, the courses that are being offered?
Yes, so
I can put that in.
yes, and I know everybody's got other questions and we're ending right now, so I apologize because we're 5 minutes late. The Ansbacher Education's website, if you go to the website, there is a list of courses. You can click at the very top that says courses and then register for all the courses. You can send out the link to your friends, and we always do free classes for everybody, so we're always uploading new classes on there to register for.
And I'll add you to the mailing list with your information card that you have.
Everyone, thank you so much for coming. Thank you, Brianna.
Thank you, Beth.
Thank you.